Hello everyone. I am presenting this lecture on rule of law. My name is Dr. Sanskriti Srivastava. So here in this presentation we are going to discuss about rule of law, its meaning and scope. First of all, supremacy of law is very important. Rule of law according to Dicey means the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power or wide discretionary power. It means the exclusion of the existence of arbitrariness on the part of the government. Basically, here, rule of law means supremacy of law. It is also said that law is the king of kings. That means even Supreme Court, even the highest court of the country is bound by the law, is bound by the constitution. Moving forward to the next slide. This, in essence, means that no man can be arrested, punished, or be lawfully made to suffer in body or in goods except by the due process of law and for the breach of a law established in the ordinary legal manner before the ordinary courts of the land. This means that no one can be arrested without knowing the grounds, or we can also say that rules are equal and they are same for everybody. Even if somebody is very powerful and their child gets into a crime, that doesn't mean that they will be relieved easily. Law is equal for all and that must be maintained in all the conditions. The law sees everybody with equal eyes. It is not different, although reasonable classification is permitted that we will read about in the upcoming slides. Moving on to the next slide, equality before law. While explaining this aspect of the doctrine, Dicey stated that there must be equality before the law or equal subjection of all classes to the ordinary law of the land administered by the ordinary law courts. For example, in India there is Supreme Court, High Courts in all these states and various sessions court are also there. Dicey believed that the exemption of civil servants from the jurisdiction of the ordinary courts of law and providing them with special tribunals was the negation of equality. So basically, Dicey was not supportive of the view that the administrative officers or other officers of the country should be served with different sort of law. He wanted same law for everybody. Law should not discriminate between an officer and a normal citizen. Or we can also say that law should be equal for a person holding a position in the government as well as an individual who is not a government servant. Moving forward, he stated that any encroachments on the jurisdiction of the courts and any restriction on the subject's unimpeded access to them are bound to jeopardize his right. Yes, this is very true that if courts are curtailed jurisdiction, for example, if they can't summon a police officer or if they can't summon an authority, that sort of discriminates between a normal person and a government servant. Moving forward to the next slide. Thus, he emphasized the role of the courts of law as guarantors of liberty and suggested that the rights would be secured more adequately if they were enforceable in the courts of law than by mere declaration of those rights in a document. So, Dicey emphasized on the role of the courts because courts guarantees liberty and they suggest that it would be only equally and adequately enforced if courts are there to enforce them and not just the books or the law books or the bare acts. The doctrine of judicial review is embodied in the Constitution, and the subjects can approach the High Court and the Supreme Court for the enforcement of fundamental rights. If the executive or the government abuses the power vested in it, or if the action is nullified, the same can be quashed by the ordinary courts of law. The doctrine of judicial review basically is given in the Constitution and it provides that courts can always take action if there is any violation of fundamental rights. Moving forward to the next slide. The Supreme Court of India in Chief Settlement Commissioner Punjab versus Om Prakash observed that in our constitutional system, the central and most characteristic feature is the concept of the rule of law, which means in the present context, the authority of the law courts to test all administrative action by the standard of legality. Moving forward to the next slide. The court added that the doctrine of rule of law rejects the conception of the dual state in which government action is based in a privileged position of immunity from control by law. Basically, this slide means that in rule of law, everyone is equal, so there is not even a single person who can evade that. Even people having privileges or immunities have to be bound by the law. Law cannot differentiate or discriminate between people on the basis of their caste, creed, their position, etc. Moving forward to the next slide. Following are the exceptions to rule of law. First is equality of law does not mean that the powers of private citizens are the same as the powers of public officials. Example, a police officer has the power to arrest which the private person or citizen does not have. So this is a very reasonable sort of an exception because only and only certain agencies which are empowered by the government and by the acts can arrest. No one can arrest a person walking on the road without any particular reason because they don't have the power to do so. The rule of law does not prevent certain classes of persons from being subject to special rules. For example, the armed forces are governed by military laws. Martial laws are there and the government does not interfere in them. If any person belonging to military commits a crime, they are prosecuted under the martial law and not under the ordinary law. So these are the reasonable exceptions which are very well justified as law has to be flexible. It cannot be equal for the unequals. Next is ministers and other executive bodies are given wide discretionary powers by the statute because they have to perform certain functions, and if they are not empowered enough, they will not be able to perform those functions. Next is certain members of society are governed by special rules in their professions like lawyers, doctors and nurses. So these people are also governed, for example, for lawyers, there's Advocates Act, for doctors, there's medicine laws. So these laws differ for these different category of persons as they are doing their different jobs, they are practicing their different professions. So there is different law and person cannot claim that he or she wants to be governed by these laws or cannot ask that why lawyers and doctors are not subject to the same laws as their profession demands so they have different laws for them. Moving forward, the founding fathers of India accomplished what the rest of the world thought impossible. For example, establishing a country that would follow the letter of the law and implement the rule of law in all matters such as the protection of the rights of the people, equal treatment before the law, and protection against excessive arbitrariness. The Constitution of India has provided enough mechanisms to ensure that the rule of law is followed. Through its decisions, the courts have strived to reinforce these mechanisms and ensure smooth justice delivery to all the citizens. Moving forward, problems such as outdated legislation and overcrowded courts are but small hindrances, and bodies such as the Law Commission of India work towards ironing out these problems with the aim of achieving a system where there are no barriers to the smooth operation of the rule of law. These are small problems which can be tackled very well by the courts in India. So, these were some of the principles which are very important about the rule of law. So basically, Article 14 in our constitution talks about rule of law and it provides all these things. So here I'm ending this lecture. Thank you.